Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
With no delaying for what you saying, yo. I'm silly with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, I be wild in the studio. You don't wanna vibe, me, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the toolie, yo. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Let me see just what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Let me see just what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Let me see just what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Let me see just what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Let me see just what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Let me see just what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Hello, 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 everyone. Welcome back. It's me, your girl, Diva Divine Light. And we are going to talk about today the constitutionality of victim impact statements. And we're also going to learn about the federal sentencing advocacy, which is usually what happens at sentencing hearings um, with the defense lawyers and how they advocate the credibility. They talk about the credibility of the defense attorneys. So when you're doing sentencing and you're being an advocate as a defense lawyer, um, the judge also examines the credibility of the lawyer, which I found to be very interesting. So, what I'm going to do is I'm going to read over a couple of passages from the when it comes to sentencing criminals and the constitutional rights of having impact statements from the victims being heard at sentencing hearings when a criminal has been convicted and it comes down to giving him his sentencing. Um, so This article that I had found um, was written by a Missouri law firm. Um, yeah, from the Missouri School of Law. Okay, so it talks about the introduction, and the introduction to this is that it says that most jurisdictions around the country permit juries to consider victim impact statements. And these statements are taken from the family of a victim of a violent crime relating to the family's loss. During the sentencing phase of criminal trials. So, this is when it happens. And in 1994, the Missouri Supreme Court followed this trend in the State versus Wise by approving the use of victim impact statements and allowing the statements to be presented to the jury at the sentencing stage of a capital punishment trial. So, in non capital punishment trials, the victim presents impact statements relating to the economic loss, physical injury, and changes in his or her personal welfare. And then in murder trials, the surviving family members present victim impact statements relating to the effect of the crime of the victim's family. So when it comes down to victim impact statements in a non capital punishment trial, like, say, for instance, with R. Kelly's trial, um, it says that the Missouri statute, okay, allows that certain victim impact statements um, typifies similar statutes of other states. So the District of Columbia and the Federal Rules of Criminal Procedure, and it reads as follows: that a victim impact statement shall, one, identify the victim of the offense, two, itemize any economic loss suffered by the victim as a result of the offense, and then three, identify any physical injury suffered by the victim as a result of the offense, along with its seriousness and permanence. Number four, describe any change in the victim's personal welfare or familial relationships as a result of the offense. Five, identify any request for psychological services initiated by the victim or the victim's family as a result of the offense. And six, to contain any other information related to the impact of the offense upon the victim that the court requires. So, these are the rules of the criminal procedure for the District of Columbia. Okay. And it pretty much follows throughout the states because at first it was only certain amount of states, a small amount of states followed this law. Not everyone agreed with it. Um and it also says that as demonstrated by the United States Supreme Court's equivocal position, The introduction of family impact evidence at the sentencing stage of a murder trial remains very controversial. Now, regardingly, in 1991, the court overruled its precedent that victim impact statements violate the Eighth Amendment's prohibition against cruel and unusual punishment by holding that victim statements are constitutional in capital punishment cases. So when it comes to murder trials, they didn't want the impact statements. They felt like it just wasn't necessary. It was going against the Eighth Amendment. Now, it said that despite the constitutionality of the introduction of a victim's family statements, the statements have been severely criticized for one, rendering the sentencing of a criminal an arbitrary process, two, imposing the death penalty based on factors that were unknown to the defendant and irrelevant to the defendant's decision to kill, and three, misplacing the jury's attention on the victim instead of the defendant at the sentencing stage of the trial. So, notwithstanding the controversy, the Missouri Supreme Court upheld the prosecutor's use of victim impact statements in Wise. Now, as I said earlier, they were talking about the United States versus Wise. That was a case. And they said that by relying heavily on the United States Supreme Court's constitutional approval of impact statements in Payne versus Tennessee. Now, prior to the sentencing of an offender in a serious case, victims or their families should have the opportunity to inform the sentencing body of the crime's physical, psychological, and financial repercussions on the victim or on the victim's family. So, jurisdictions may do this in one or several ways, including A, a written statement prepared by the victim to be included in the probation department's pre sentence report on the offender, or B, a written statement prepared by the probation department after consultation with the victim of the victim's representatives, and or C, an oral statement by the victim's representative before the sentencing body. So when the girls are in the R. Kelly case, when the girls are going to go to do these victim impact statements, they can write them themselves. Okay. And when they do that, it is presented to the probation department with the PSR report. Like, we know that R. Kelly, right now, the lawyers between the government and the defense team are objecting to certain things in this report. So, as we know that these reports have been sealed, and there's reasons for that. There's certain things in there that we, the public, are not allowed to see. Very personal details and things of that nature that we cannot see, because then it's violating some type of right towards the victim and the defendant. Um, And then they can also have a written statement prepared by the probation department after consultation with the victim and the victim's representative. So there can also be a statement made when the young ladies go to meet up with the probation department to put information in for the PSR report. And then also there can also be and it would be either from the lawyer or from her, one or the other. And then also there's an oral statement by the victim's representative, which would be the lawyer. And the lawyer would stand in front of the judge and everyone else in the court um, before the sentencing and make the statement for the victim. Um, Now, when it comes to the legal background of the constitutionality of the victim impact statements, um, there are victims' rights, and there was a victims' rights movement. And the rise of the victim rights movement started in the 1960s in conjunction with the women's rights movement, claimed that the criminal system mistreated rape victims. And one premises behind both movements was that for most crimes, there is at least one innocent victim whose life has been harmed. And supporters of the movements contended that the criminal justice system was entirely unsympathetic to victims by denying them a formal role in the judicial system. So, exploiting them to prosecute the criminal and failing to provide rehabilitation or assistance after sentencing of the criminal. So, supporters advocate that the law should give victims a more meaningful role in the criminal justice system. Now, accordingly, the victims' rights movement sought to accommodate the needs of the victim and to balance the interests of the victim with the rights of the defendant. Now, supporters have achieved reform in various ways, including the passage of state statutes requiring that the victim be informed of the time and place of criminal proceedings, and the award of restitution to victims. So, in addition to state legislation, Congress enacted the Uniform Victims of Crime Act of 1992, which provides that the victim has one, the right to be present whenever a defendant has the right to be present at a court proceeding under the Confrontation Clause of the United States Constitution, and two, the right to be informed of the date, time, and place of the trial, and three, the right to counseling information, and four, the right to be free from harm and harassment. Furthermore, these rights survive the victim and pass to the victim's family upon the victim's death. So, if, say, for instance, it's a murder case, right? So these rights will pass on to the victim's family. So, if that victim is dead due to this crime that was committed on the victim, the family has those same rights as the victim, who is now no longer with us. So, Congress also enacted the Victim and Witness Protection Act of 1982 to enhance and protect the necessary role of crime victims and witnesses in the criminal justice process. So, this act amended the federal rules of criminal procedure to require the inclusion of victim impact as part of the pre sentence report submitted to the sentencing authority. So, victim impact evidence is one of the most controversial means of vindicating victims' rights. So, victim impact evidence, written statements, or oral testimony allows victims or their families to tell the sentencer, which we know would be the judge, of the crime's impact on their lives. So, advocates of victim impact claim a twofold purpose for the statements. So, first is the victim gains a sense of dignity and respect if allowed an active role in the sentencing decision. And second, allowing victim impact will more effectively equate the criminal's punishment to the full extent of the harm caused. So, as I said, the Victim and Witness Protection Act of 1992, okay, was amended. 1987, 1984, amended under sections 3579 80. So it's 3579 through 80, through 3580. And it relocated the sections to the 18 United States Code section, which is 3663 through 3664. So, in addition to victim impact statements, the Victim and Witness Protection Act provides victims with restitution, protection against imitation, and a federal, and I quote, son of Sam law, which prevents felons from profiting from the sale of his or her story. So that's very interesting to know. So the victims are also protected by this law called the Son of Sam law. Okay? And this law is to prevent the felon, which would be the defendant. In the case of R. Kelly, it would be R. Kelly. He cannot profit from the sale of his story. So even after he's been convicted now and he's sentenced and he's sitting in jail and he decides to tell his story to someone, a news reporter, a TV show, an author to write a book, he cannot profit off of that according to the Son of Sam law. Isn't that interesting? Wow. Now, the victim impact statements and the Eighth Amendment. Now, remember how I was saying that before, that they said that it might be violating the Eighth Amendment clause, especially for the victims to come out and make impact statements when it comes to someone who's facing the death penalty or some type of murder trial. It states that the United States Supreme Court's indecisiveness, the courts and legislators around the nation have wavered on the issue of the constitutional of victim impact. of the constitutionality of victim impact. Now, in the 1980s, for example, 4 states restricted the admissibility of victim statements to non-death penalty cases. Okay, and that would be like in cases like R. Kelly. He's going to face life in jail, but it's not a death penalty case, right? Now, in California, it was banned, the victim impact statements in all criminal cases. And this was in the 80s. Now, as of currently, after the Payne versus Tennessee case, excuse me, some states restricted the admissibility of victim statements to cases not involving the death penalty. However, 49 states allow victim statements taken from the victim, and most states allow victim statements from a victim's family at the sentencing stage of criminal trials. So as of current, there are 49 states that allow this to happen. So I just thought that was important for everyone to know. Because R. Kelly will be sentenced in a couple of weeks. And I figured I'd kind of get us through this one phase right now real quick. So the next, they talk about the current treatment of victim impact statements, right? So as we know, 49 states are currently, they allow the sentencer, which would be the judge, to consider some form of victim impact statements in non-capital punishment cases. Now, most jurisdictions, including Missouri, the District of Columbia, and the federal court system, are closely aligned with the United States Supreme Court decision in Payne, and, in the case Payne versus Tennessee, right? And permit victim statements from the victim's family regarding the impact of the victim's death on the family. So, of the states that allow victim statements from family members, Idaho requires that the statements are used only in non-death penalty cases. Other states that allow impact statements from family members impose various other limitations on their use, most typically requiring that, one, the statements must be general and cannot devolve into the victim's character and worth, and two, the statements must be read by the prosecutor and not in the form of the testimony from family members, and three, the statements cannot be unduly prejudicial to the defendant. 4, the statements must adhere to victim impact statement forms. And 5, the statements can be used only when a judge, instead of a jury, is sentencing the defendant. So that's for the state of, what state was that? Idaho. Okay, that's their thing in the state of Idaho. Okay. Then it goes on to say that only 2 states do not provide for victim impact statements from family members of victims and only allow victim statements from the victim. So prior to the case Wise, only one Missouri death penalty case followed the Payne law in permitting victim impact statements. So in this case, however, the prosecutor read the victim impact statements, which made vague, general, and brief reference to the defendant's victims and not to the victims' families. So, Missouri courts more commonly circumvented the Payne law by scrutinizing testimony purporting to be victim impact and concluding that it simply did not qualify as victim impact evidence. So, since its decision in the Wise case, however, the Missouri Supreme Court has reaffirmed its position on victim impact statements and used both Wise and the Payne cases to uphold the use of victim impact statements in the State versus Parker case. Now, the jury convicted Parker of first-degree murder and sentenced him to death. The Missouri Supreme Court upheld the statements of a victim's father regarding how the family had been impacted by the victim's death. So the court reasoned that victim impact evidence illustrates the harm from the murder. There is nothing unfair about permitting the jury to consider that harm, along with the defendant's mitigating evidence. And that's Missouri. So, all right. And I think after this, we're done. Okay. Now, we're close to the end and we're going to get to the comments of it all. The victim impact evidence from a victim's family is a relatively new and controversial concept in criminal law, right? Regardingly, state statutes restrict victim impact statements in various ways. Arguably, victim impact statements inject an arbitrary factor in deciding whether to impose the death penalty. Opponents of victim impact statements in capital punishment cases also contend that they impermissibly inflame and prejudice the jury. So, in addition, the reliability of victim impact statements is subject because victim impact statements are difficult to verify and impossible for the defendant to rebut. So a defendant's sentence should solely be based on the severity of the crime and the defendant's record, not on the emotional impact of the victim's family. So proponents of victim impact statements contend that the impact of the crime should be a factor in determining a defendant's sentence. So accordingly, proponents maintain that presentation of victim impact statements during sentencing appropriately allows the judge to reflect upon and account for the effect of the defendant's crime on the victim's family. So, victim impact statements are also important because prosecutors are not as apt as victims to convey the impact of the crime to the judge. So, although the prosecution uses the victim's testimony to put on its case, the interests of the prosecution and of the victim are not congruent. So, the prosecution mainly strives for a conviction. Now, in contrast, a victim or a victim's family seek retribution and a means of coping and closure. Thus, because victim impact statements are the only method by which to convey the crime's impact on the victim or the victim's family, they are essential in admitting the crime's impact on the record. So, allowing the victim a voice in the proceeding also creates a sense of fairness. Foremost, victim impact statements vindicate victims' rights. Although they are diametrically opposed, both defendants' and victims' rights can be safeguarded. If victim impact statements are read after the sentencing stage of the trial, both defendants' and victims' rights remain intact. So, accordingly, the risk of arbitrary sentencing would be eliminated, and victims would still be a part of the criminal proceeding by having voiced their feelings to the defendant, the court, and the public. So, victim impact statements should be a part of the defendant's sentence, not a factor in deciding an appropriate sentence. So, in conclusion of all of that, the Supreme Court pronounced that victim impact statements were cruel and unusual punishment in 1987. And then the court affirmed that victim impact statements were cruel and unusual in 1989. Currently, however, after the Supreme Court reversed its stance in 1991, almost all states allow the jury to consider victim impact statements during sentencing and capital punishment trials. Curiously, victim impact statements, once thought to be cruel and unusual punishment, are widely used in our criminal justice system to sentence criminals. The criminal justice system could better utilize victim impact statements by requiring the defendant to listen to the statements as part of his or her sentence, and the system would thereby preserve a place for victim impact in the courtroom and safeguard against cruel and unusual punishment. Sorry about that, guys. So, so what do you guys think about that? So now, back then it wasn't allowed. Now it is, thank God. And it does help with closure for the girls, for the victims, and it also helps the judge uh, on her sentencing decisions, and also notifies the defendant of how the victims were impacted by the harm that they caused to them. So, in light of all of that, I wanted to present to you guys um, a video where I found by a lawyer His name is by the law offices of Joseph Abrams. And please go and share and subscribe to his channel. I'm going to put I'm going to put his information in the description box of the video. So please, if you get a chance, check out the description and please go follow his channel, subscribe to his channel. He's been out there for a little while. He's only got 31 subscribers, guys. Let's give him some thumbs up on his videos and let's just subscribe to the channel. Show him some love, please. And he shared some great information and I thought he put it very simple for everyone to understand. So thank you, the law offices of Joseph Abrams. I appreciate your content. I will be sharing your content with my audience, and this is for learning purposes and research. I do not own the rights to any of this content. This content is owned by the law offices of Joseph Abrams, and I'm using this as a teaching tool for my commentary. And under the Fair Act use, I am allowed to use this commentary as research and a study guide for everyone. Okay. All right, let me do this. Okay, guys. If you can, once the video starts, please give me a thumbs up and let me know that you can hear the video loud and clear. Okay? I'm going on mute.
I'm criminal defense attorney Joseph Abrams. Today's video is the first in a three-part series in which I discuss the most important aspects of federal sentencing advocacy, or, in other words, how to argue for a mitigated or lesser sentence. Today, in part one, I discuss the credibility of the defense attorney as one of several important aspects of sentencing advocacy in federal criminal cases. The credibility, or lack thereof, of the defense attorney can set the tone for the entire sentencing process. So, how does a defense attorney create credibility and trust with the judge? First, the defense attorney should not attempt to minimize the defendant's crime. Do speak honestly about what the defendant did. While judges appreciate an attorney's vigorous advocacy, they want the truth. Otherwise, the judge may view the attorney as disingenuous and disregard other arguments made by the attorney.
Wow. Now, isn't that interesting, guys? The credibility of the lawyer is very, very important in this process. The lawyer has to be honest. Isn't that something? This sentencing hearing for R. Kelly is going to be interesting, guys. Can't wait to go. Can't wait to go. Let me rewind that just a little bit. Backtrack just a little bit so you guys can understand
attorney's vigorous advocacy. They want the truth. Otherwise, the judge may view the attorney as disingenuous. First, the defense attorney should not attempt to minimize the defendant's crime. Do speak honestly about what the defendant did. While judges appreciate an attorney's vigorous advocacy, they want the truth. Otherwise, the judge may view the attorney as disingenuous and disregard other arguments made by the attorney. Second, the defense attorney should not request a ridiculously low sentence. Do make well-reasoned, principled, and appropriate recommendations.
Well, Bonjean made a ridiculous sentence recommendation below the standard, 14 to 17 and a half. Ooh, that don't look good.
First, the defense attorney should not attempt to minimize the defendant's crime. Do speak honestly about what the defendant did. While judges appreciate an attorney's vigorous advocacy, they want the truth. Otherwise, the judge may view the attorney as disingenuous and disregard other arguments made by the attorney. Second, the defense attorney should not request a ridiculously low sentence. Do make well-reasoned, principled, and appropriate recommendations. This is a critical mistake made far too often. While judges welcome an attorney's sentence recommendation, requesting a too lenient sentence can sabotage your case by essentially taking yourself out of the conversation about what is an appropriate sentence. Third, the defense attorney should not repeat information that is already established in the record. Do provide relevant and helpful information. Judges are more interested in hearing something about the defendant or the case that they don't already know. Fourth, the defense attorney should not overload their sentencing memorandum with unhelpful, boilerplate language and legalese. Do timely prepare and file a well-written sentencing memorandum. Again, judges are more interested in reading something helpful about the case that they may not already know. Lastly, the defense attorney should not argue rulings favorable to the defense. Do thank the court for favorable rulings. Although this seems like an obvious point, it too occurs far more often than it should. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope this was helpful. We'll see you next time in part 2 of the series when I discuss the defendant's remorse and acceptance of responsibility for the offense as another important aspect of arguing for a mitigated sentence in federal criminal cases. I'm criminal defense attorney Joseph Abrams. Today's video is the second in a 3-part series in which I discuss the most important aspects of federal sentencing advocacy, or in other words, how to argue for a mitigated or lesser sentence. Last week, in part 1, I discussed the credibility of the defense attorney as one of several important aspects of sentencing advocacy. Today, in part 2, I discuss the defendant's remorse and acceptance of responsibility for the offense as another important aspect. Next week, in the final installment, I will discuss psychological evaluation reports and character letters as other important aspects. So, what does remorse and acceptance of responsibility look like? To begin with, judges want to see that the defendant has thought about what they have done and why they did it. Judges also want to know that the defendant has learned from the experience and that they are unlikely to reoffend.
Now, guys, do you think R. Kelly is going to show remorse and acceptance of his charges? Put a 1 in the chat if you think he is, And put a 2 in the chat if you think he's not.
So, how can a defendant demonstrate remorse and acceptance of responsibility to the judge? To begin with, a defendant's statement to the court, also known as allocution, can play a powerful and significant role in this effort, and in some cases be a real game changer. However, an insincere or attorney-scripted statement by the defendant can have the opposite effect. Also, importantly, a defendant who exercises their right to allocution and makes a statement before the court should be prepared to engage with the judge, who often will question the defendant to learn more about them, why they committed the offense, and their future plans and goals. To be sure, the defense attorney has an important role to play in preparing the defendant for sentencing, for humanizing the defendant before the court, and for helping the defendant tell a compelling story. Other things to consider include telling the judge about the positive things that the defendant has done since their arrest, such as rehabilitation efforts, performance of community service, or efforts to pay restitution to victims.
So, do you guys think R. Kelly is going to talk about his community service? I wonder what kind of community services he has been providing while he has been in jail. Singing to everyone? Huh? Is this the type of community service? Is he doing dishes in there? Is he mopping the floors? Is he teaching singing classes? What has he done for his community? And rehabilitation, sex offender classes, counseling classes, reading and writing classes. What is he doing to rehabilitate himself? And is he going to be nice enough to just say, well, here's a pot that I have holding on the side, because I got money everywhere. Here's $5 million, and that's my restitution. The girls can pick out of that fund, just because I know the restitution amount might be 2 million, but I'll give them 5. Huh. That I wonder how that's gonna go. Oh Lord, I can't wait.
Other things to consider include telling the judge about the positive things that the defendant has done since their arrest, such as rehabilitation efforts, performance of community service, or efforts to pay restitution to victims. Another important issue to bring to light for the court is the financial and emotional support that the defendant provides to their family or other persons. However, and perhaps contrary to conventional wisdom, it is usually not a good idea to bring young children to court. Rightly or wrongly, it is often viewed as an emotional ploy by the defense.
And I wonder how that's gonna go with providing the information of him supporting his family. That's not gonna look too good, because they're gonna be like, well, prior to your arrest, you got arrested for non-child support payments. Okay, my man. And in the divorce decree, it said that you had to pay them and you stayed away from them and this, that, and the third. Yeah, I don't think that family support thing is gonna go too well for him.
This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope this was helpful. We'll see you next time in the I'm criminal defense attorney Joseph Abrams. Today's video is the final installment in a three-part series in which I discuss the most important aspects of federal sentencing advocacy, or in other words, how to argue for a mitigated or lesser sentence. In part one, I discussed the credibility of the defense attorney as one of several important aspects of sentencing advocacy in federal criminal cases. Last week, in part two, I discussed the defendant's remorse and acceptance of responsibility for the offense as another of several important aspects. Today, in the final installment, I will discuss psychological evaluation reports and character letters as other important aspects of sentencing advocacy. So, how are psychological evaluation reports and character letters viewed by judges? Well, to begin with, most judges understand that mental illness is pervasive among criminal defendants, and they welcome psychological evaluation reports to better understand the defendant. However, and not surprisingly, judges will only give these reports weight if they are credible. For example, if the report indicates that mental illness prior to the offense was in fact a contributing factor to the defendant's conduct, this is likely to be viewed by the judge as important information. On the other hand, if the report merely states the opinion of a paid professional who spent maybe a couple of hours with the defendant while awaiting sentencing, this is not likely to carry much weight with the judge.
Oh, did you hear that, guys? So, when they do part of the PSR report and they do the psychological analysis of him, if they find that there was real mental issues with him, maybe being born this way or, something to that effect that would be of importance, fine. The judge could put that into consideration. But if it's just some report on where they say, well, I think he is, and he might be this, and it looks like it could be, and, because the judge is going to be like, yeah, I don't think so. Interesting. I'm telling you, this is going to be interesting, guys.
There is a similar, if slightly different, dynamic at play with character letters. First, the quality of the letters is significantly more important than the quantity.
Okay, did you hear that? When it comes to character reference letters, quality over quantity. So, let's not send 100 letters, okay, to the judge for R. Kelly, because they're not going to be used. The judge is going to go, what? Throw half this shit out in the garbage.
On the other hand, if the report merely states the opinion of a paid professional who spent maybe a couple of hours with the defendant while awaiting sentencing, this is not likely to carry much weight with the judge. There is a similar, if slightly different, dynamic at play with character letters. First, the quality of the letters is significantly more important than the quantity. A campaign to obtain as many letters as possible is usually a waste of time and of little help. Instead, the letters should inform the judge about the defendant's life and good deeds that only the writer can know and wasn't even shared by defense counsel. Also, keep in mind that inarticulate descriptions of a defendant's kindness can often resonate more powerfully than form letters that list all of the defendant's supposedly great attributes. It's also not particularly helpful for the writer of the letter to say, in effect, that they can't believe the defendant would commit such an offense. Conversely, an employer who is aware of the offense and yet commits to rehire the defendant in a character letter, that can be particularly powerful. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. This concludes our three-part series on federal sentencing advocacy. I hope you found it helpful, and we'll see you next time.
Interesting. Very interesting. So, let's see how this goes. So the character letters are more persuasive when you talk about the person being kind to people, as opposed to the attributes that they've contributed. Um, so, and it's better off from people who know the person, know him. So I got a couple of more videos to present here. What is the next one? Okay, so the next video that I'm going to present to you guys talks about the criminal, what factors does a federal criminal procedure need? And
what factors does a...
Okay. And this video is from James Publishing. And okay. And I'm going to leave their channel in the description box as well. So if you can, please go and subscribe to their channel. Give them a thumbs up on the video. Thank you. And as I said, I do not own the rights to this content. It belongs to James Publishing, and I am using this content for research and teaching factors in law. Thank you, and big shout out to you, James Publishing, for letting me use your content for fair use of learning and research.
What factors does a federal criminal court consider in sentencing? If you're facing federal criminal charges, you need to know what type of a sentence may be imposed in order to make intelligent decisions about a plea agreement and other aspects of your case. Sentencing in federal criminal cases is a complex process that requires the sentencing judge to consider multiple factors in making his decision. Those factors are the nature and circumstances of the offense, the history and characteristics of the individual defendant, the kinds of sentences available, the sentence and sentencing range provided for in the federal sentencing guidelines, relevant policy statements issued by the Federal Sentencing Commission, the need to avoid unwarranted sentence disparities for similar crimes, the need to provide restitution to any victims, and whether the sentence imposed is sufficient but not greater than necessary to reflect the seriousness of the offense, to promote respect for the law, to provide just punishment for the offense, to deter future criminal conduct, to protect the public from further crimes by the defendant, and to provide the defendant with needed educational or vocational training, medical care, or other treatment in the most effective manner. When imposing a sentence, the judge must make an individual assessment of the facts of the case and all the factors listed above, and explain the reasons underlying his decision so that if one of the parties wants to challenge the sentence, it can be meaningfully reviewed on appeal. Ultimately, the goal in federal criminal court is to impose a sentence that is fair to both the defendant and the government.
So that is the federal criminal procedure and the steps that they have to take before sentencing. They have to go through all those steps. That is a process. Everything is a process, guys. When it comes to the law, everything is a process. So the next video I'm going to present to you guys talks about how the federal prisons, the Federal Bureau of Prisons, the BOP, how they, after sentencing, how they figure out where you're going to go, where they're going to be shipping you to. So this video talks about how does the Federal Bureau of Prisons designate defendants for service of their sentence. And this is also by the law offices of Joseph Abrams. Shout out to you, Joseph. Thank you so much for your content and your information. I am using your content for information and research. Let me go on mute.
Welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question. Following the imposition of a federal sentence of imprisonment, the Bureau of Prisons, also known as the BOP, begins the process of designating the defendant to a facility for service of their sentence. Under federal law, the BOP has exclusive discretion to assign the defendant to any facility in the country. The BOP's Designation and Sentence Computation Center, located in Grand Prairie, Texas, makes the initial custody classification and designation based on BOP variables and public safety factors. It also calculates the exact sentence length. After the inmate is designated to a facility, institution staff are then responsible for the security and custody classification for the inmate. So, what are the factors taken into account in the designation decision-making process? First is the level of security and staff supervision that the inmate requires. For example, if an inmate has a high security level, it's important that they are designated to an institution that employs sufficient and capable staff. Another factor is the inmate's medical care needs. So, an inmate with serious medical care needs may be designated to one of the BOP's 6 specialized medical care facilities, such as the one in Springfield, Missouri. Another factor is the inmate's rehabilitation needs, such as substance abuse treatment, education and vocational training, and mental health treatment needs. These types of programs are widely available across BOP institutions. There are also a number of administrative factors that are also considered. These include judicial recommendations made on the record at the inmate's sentencing hearing. Separation needs, that is, the need to separate certain inmates from one another. And security measures required to ensure the safety of victims, witnesses, and the general public. Lastly, proximity to the inmate's release residence is also taken into account. Inmates are designated as close as practicable to their primary residence, and again, to the extent possible, to a facility within 500 miles of that residence. In closing, I'd like to address one additional factor, and that is a defendant who is sentenced while on bond will often be granted by the judge a self-surrender date to voluntarily surrender at the BOP facility to which they have been designated. Defense attorneys and defendants should always request a self-surrender date if possible. Why? Because the BOP draws a positive inference from the court's determination that the defendant is sufficiently trustworthy to surrender voluntarily, which will favorably impact the inmate's classification and designation decisions. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful, and we'll see you next time when I answer another of your questions about federal criminal law.
So I wonder if they're going to put him in a minimum, medium, or maximum facility. I don't think they would put him in a maximum, maybe a minimum or a medium facility, because it is his first offense, you know. Plus, he is a star, you know, his status. Yeah, I think he would go to a medium. I don't know, either a medium or a minimum. Okay, so I found another video that talks about how to get a reduced sentence in a federal case.
Hi, my name is Diane Bass, and I'm a federal criminal defense attorney.
And her name is Diane Bass, and she's a criminal defense attorney. And I do not own the rights to this video. I am using this to do research and for teaching purposes only. Shout out to Diana Bass. Her video will also be in the description box. Please go subscribe to the channels that are in the description box of the video. Thank you. Please make sure you give everybody their props.
In Orange County, California. I want to talk to you about what it means to cooperate with the government in a federal case. Now, many people have been hearing the term cooperation on the news with many of the cases that have been in the news lately. So what does that mean? Cooperation means that you are providing information to the government in the prosecution of someone else in order to reduce your sentence if you are facing charges. So what does that look like? So say you're charged with a federal criminal case and you have information about someone else who has committed an offense, whether they're a co-defendant on your case, someone else that's in your same case with you, or someone else that has not been charged yet, but that the government is investigating. So the U.S. Attorney's Office would say to me, Diane, I see you're representing so-and-so, and we would like to talk to him or her. They might have information that we're interested in. So I talked to my client about the situation. Cooperation does require a guilty plea. So it presupposes that you are going to plead guilty in your case and that you are doing this for purposes of sentencing to reduce your sentence. How does that work? The U.S. Attorney will write me a letter, which is called a proffer letter, or also known as a Queen for the Day letter, which says that anything you say during this meeting cannot be used against you in any proceedings unless it's being used to pursue other leads or to impeach you if you were to say something different. So say that you were to say, you know what, I don't want to plead guilty, I want to go to trial. And you get up on the stand and you say something completely different than what you told the attorneys in that meeting, then they can say, well, Mr. or Mrs. So-and-so, do you recall a meeting that we had on X date and you said Y? So it can be used against you for that reason. Once you sign the proffer letter, you will sit down in a meeting with the U.S. Attorney, your attorney, and any number of agents. I've been in a room with 1 or 2 other agents. I've been in a room with 10 agents from 4 different agencies, depending on the case. They will ask you everything that you know about your case and this other person's case. During this meeting, they are going to ask you questions that they know the answer to, and they are testing you because the most important condition of your proffer, your letter and your Queen for the Day, is that you be completely truthful. So this doesn't just mean that you are honest, that you answer their questions honestly and completely, so you can't hold back. Now, obviously, if this is a fraud case and there's a dead body in your freezer, we're not going to be talking about that. We're going to be talking about what they are asking about. So after you've had this meeting, which is terrifying for many people, I do promise you, you will feel better After the meeting, I've had any number of clients tell me after the proffer, wow, I feel so much better. I got that off my chest. Then they will come to me and they will give me an offer for your case. They will not, however, tell me how much credit you are going to get for your cooperation. So when you plead guilty, you are agreeing, because it's a cooperation plea agreement, to cooperate with the government. You are agreeing to testify at any proceedings they ask you to testify at, and to essentially do anything that they ask you to do. If it's wear a wire, if it's to make a recorded call, whatever it is, you've agreed to do that. And yes, that can be scary and that can be dangerous. These are all things that are taken into consideration when the U.S. Attorney makes the recommendation to reduce your sentence. So once you sign the cooperation agreement, again, you have this obligation, this ongoing obligation right up until sentencing to do whatever it is that they ask you to do. I will tell you that I would say 90% of the time, that meeting is it. There may be 2 or 3 meetings in some cases, and very few clients actually go out and wear a wire or do a controlled phone call or testify at trial, because only 2% of all federal cases actually go to trial. So most people, once they see what the evidence is against them, they will plead guilty. So you won't have to testify. And at some point, it will be revealed that you did give this information, although your information and your identity is kept secret for as long as possible. So the reason that the U.S. Attorney won't tell me, and then in turn you, how much credit you're getting is simply this. You are going to potentially be a witness. Now imagine if you get up on the witness stand and you're going to testify against your neighbor. And you're going to say, yes, my neighbor did this. Well, your neighbor's lawyer is going to get up and he or she are going to say, well, Mr. So-and-so, isn't it true that you entered into a cooperation agreement with the government? And isn't it also true that you were facing a mandatory minimum sentence of 10 years? But by testifying, the government has agreed to give you 2 years. And so of course you're going to lie. Of course you're going to say anything that you need to say to get yourself out of trouble. Isn't that true, Mr. So-and-so? By not telling you how much credit you get, the defense attorney for that person can't make that argument. And all you can say is, I do not know how much credit I'm getting, and I was just told that I have to tell the truth. So I am telling the truth. Now, is it possible that I'll get a reduced sentence? Yes, but do I have any idea how much of a reduction I'm going to get? No, I have no idea. So it is a leap of faith, but I will tell you, in my 22 plus years of doing federal criminal defense, I have never seen a U.S. attorney not give somebody credit where credit is due. And the amount of credit varies widely based on so many circumstances, so many factors that I can't even give you a ballpark. But certainly when you come and see me and we talk about your case and we talk about the facts and the information that you may or may not have, I can make educated and experience-based guesstimates on what might happen in your case. Of course, I cannot make any promises. No one can make any promises. Ultimately, it is the judge who determines a sentence in a federal case. And that's pretty much cooperation in a nutshell.
Well, all right, guys, that is the presentation for the day. I hope you guys were able to absorb all that information and understand what is going on for R. Kelly, which will be happening in the next, let's see here. Uh, 7, 14, 15, 16, 17, about 17, 18 days. R. Kelly will be sentenced June 29th. Yes. June 29th, guys. The information is scrolling on the bottom of the screen. Sentencing hearings for June 29th, 2022. His trial for the Chicago Northern District of Illinois is August 1st, 2022. Guys, don't forget, please hit that like button. Thank you. Don't forget. And if you are on the replay, make sure you leave your comments in the comment section of the video, guys. Thank you so much. And if you would like to be a part of my members only crew, it's $1.99 a month. You can join. Hit the join button on the bottom of my video. And Diva Divine Light is out. Peace.